Hello, and welcome. I'm Will Hunter Dickinson, and today we'll be taking a deep look into the law surrounding murder. Murder is one of the oldest crimes in the English legal system. The definition of murder has undergone little change since Lord Coke's definition, created in 1797. This definition is when a man of sound memory and of the age of discretion unlawfully kills within any country of the realm any reasonable creature in being under the king's peace, with malice aforethought, either express or implied, so as to wound or hurt the party, and that wound or hurt kills within a year and a day of the same. We'll come back to this definition shortly, but now I'm afraid we have come to some disclaimers. This video, and indeed this channel, is in no way legal advice. I'm not a solicitor or a barrister, so do not take this video as any sort of legal advice, nor is this a learning guide or a source for university students. It's not meant as such. It is in fact a short, fun look into murder law in the UK. Now, to give a good overview of murder, we need to step back for a moment from Lord Coke's definition and the 1700s in general, and go all the way back in time to the Neolithic. Murder has, as an act, existed probably since the dawn of human civilization, with archaeologists finding possible evidence of murder as far back as the Neolithic. However, this is not the focus of this video. What concerns this video is the history of the modern law of murder. This means bypassing large amounts of history altogether, all the way up to the 12th century, where our story begins. Murder has been socially unacceptable since the Dark Ages, but without any specific reparations or specific remedies in law, behaviour occurred more often than society could reasonably afford, and there was no reason for people not to carry out this behaviour. Private reconciliation and wereguilds settlements were the norm, but this meant that it was for individuals to hold individuals to account for their actions in regards to murder. And if this was done, which it seldom was, the responsible party was supposed to pay an amount of money to either the surviving victim or the victim's family to recompense them. But such systems often failed, and they didn't really dissuade anyone from murder anyway. For the poor, it was really unlikely that they would have the resources to try and pursue such an action. For the rich, it was often seen as a small price to pay for the removal of an opponent or a hated enemy. It was also a system that suffered from a massive class divide, with those poorer in society having no real way of holding the rich accountable for such heinous acts as murder, even though they were perpetrated against them or their family members. It just did not work as a system. So it was clear that some change had to happen in the 12th century. It's really from the 12th century that our entire idea of a public offence, a crime perpetrated against the state, not just an individual, is created. And they did this when they outlawed wereguild settlements and private reconciliations. The king assumed the authority for a new crime and created it as a public offence, as a crime perpetrated against the state, not just an individual, which meant that everyone could be held accountable for their actions against any other individual, no matter who these individuals were, whether they were wealthy or poor. It was a novel concept that had never been seen before, and as such it did take a while for such a system to really fully embed in. The new offence was punishable by death and had strict self-defence laws created around this. Later in the 13th century, the king appointed local jurors to adjudicate on murder trials, so that the king didn't have to do all of that himself. Minor changes to the law did occur after this, but modern law of murder still is not recognisable from this version of murder to Lord Coke's definition. These two still are very different concepts. The first stage of Lord Coke's definition, created in 1797, is unlawful killing. This makes sure that military killing, either in war or other operations, does not fall into the category of murder. Such killings are in the public interest, as they ostensibly are for the purpose of protecting people, and it's felt it would be vastly unfair to punish those who protect people. Protection of individuals who take lives in this way is important because discouraging this type of public good through prosecution would lead to detrimental effects on society, such as no one joining the army for fear of reprisal if they do their job too well. It also protects police forces from the same fate if, in the course of their duties, they take a life. This does not preclude prosecution if the killing is outside of that setting, or even prosecution for other crimes. In order for the prosecution to prevail in court, they must prove that the death of the victim was caused by an act or omission of the defendant. The case law that cemented what has to be proven in this case is the case of Crown against Gibbons and Proctor. It is also worth noting that in order to hold the defendant to account in this way, the defendant has to be above the age of criminal responsibility, which in the UK is 10. The second stage of Lord Coke's definition is within any country of the realm, any reasonable creature in being. This means that all territories that fall within the realm are subject to this law. Although this was more important when Lord Coke coined the definition, which was in the age of empire, it's still somewhat important as a number of overseas territories rely on this law. Reasonable creature in being includes every human being, but does not include unborn fetuses. The boundaries between who does and does not come into this category are somewhat unclear, with courts and judges taking very different approaches at various different times. But the boundaries do tend to fall, as once a baby is born, it is included, and once a person is declared brain dead, they are not included. The third stage of Lord Coke's definition is that the killing has to have been under the King's peace. This works in tandem with the unlawful killing to preclude killing in warfare being included as murder. The fourth stage of Lord Coke's definition is malice aforethought. either expressed by the party or implied. Malice aforethought is a rather nebulous term used in law. It tends to denote some kind of premeditation in the crime, in this case the killing, and it means that the killer has to have held some kind of malicious intent in their actions. Malice aforethought is the other part that the prosecution must prove in order to convict. If both parts are proved to the criminal standard of proof, which is that the jury must be convinced that the events happened beyond all reasonable doubt, then it's up to the defense to bring up the defenses in court. This leads us nicely onto the defenses. I'm only going to give a very brief overview of these, as it's really a subject for another day and another video. The defenses include loss of control, self-defense, and diminished responsibility. All of these are partial defenses, and insanity, which is a full defense. Partial defenses, if proven, merely reduce the offence from murder to manslaughter, whereas full defences mean that the case is dropped. If none of these defences is proven, and the offence is then proven, the legal penalty is life imprisonment. This was changed from death in the Abolition of Death Penalty Act 1965 and was proven to not be incompatible with the Human Rights Act. Thanks for watching. Remember to like and subscribe to my channel with the bell icon so you don't miss any more uploads. And I hope you will all be back for my next video. I will see you guys later, but for now, goodbye.